Back to all the participants to the fifth and the last day of the international workshop on designing digitally robust research libraries for the 21st century, organized by Geo Institute in collaboration with AICTE. We will now begin with the first technical session of the day, which is the 11th technical session of the workshop on the topic digital content creation, technologies, copyright, licensing and right management by Dr. Akhtar Parvez. Dr. Akhtar Parvez is University Librarian at Maulana Azad National Urdu University, Manu in Hyderabad, and is Nodal Officer for all the departmental and 12 satellite campuses libraries of the university. Prior to joining Maulana Azad University in January 2017, he worked as librarian at the prestigious Indian Institute of Management, IIM Indore. Dr. Parvez has about 33 years of professional experience of working in prestigious institutions, which include National Council of Applied Economic Research, the American Center, USIS New Delhi, Delnet, India International Center, ICRA, and IIM Indore. In addition to serving to important academic committees in various capacities, he is the managing editor of Journal of Library Management and is on the editorial board of the International E-Journal of Library Science and International Research, Journal of Library and Information Science, published by King Saud University, Riyadh, Saudi Arabia. He is currently a member, Board of Studies, Department of Library and Information Science, Osmani University from the period June 2021 to June 2023. Dr. Parvez was recognized as the Outstanding Management Librarian by Association of Indian Management Scholars and Institute of Rural Management Anand, IRMA. He is the founder secretary of Management Libraries Network, ManLibNet, and has been contributing to ManLibNet activities since 1998-99. To give back to the LIS community, in May 2021, Dr. Parvez played a significant role in forming Help LIS Mission to assist those LIS professionals and their families who have been severely affected by COVID-19. Over to you, sir.
Thank you, Tushar, for a very generous introduction. And thank you, Dr. Sri Kumar, for giving me the opportunity to speak in this prestigious program, which is, of course, by Geo University and AICTE. So I'm very thankful to you as always. And as I always say that you are my boss in ManLibNet, you say I am your colleague. So very nice of you. Thank you very much. So let me just say a very good evening to all the participants. And I'm very sure all the participants must be having a good time, in this workshop. And more because, it seems it is quite interactive, what I have been told by Dr. Sri Kumar a few minutes back. Let me just share my screen with you so that you are able to see my presentation. Just a second, please.
Yeah.
Hope you are able to see the presentation.
Yeah.
Okay.
Just to go to the presentation also.
Yeah. So, okay. So, just a second. Yeah, so this is the topic of my presentation, as has been said by my friend Tushar. And I would be speaking mainly on, the aspect of copyright, because this is something, which we encounter every day, the issues related to copyright and, of course, intellectual property. So my topic, as I said, is digital content creation, copyright, licensing, and rights management. But my focus would be copyright. So what is intellectual property? I'm sure all of you know that anything, which is the creations of the mind is intellectual property. Like, for example, inventions, then you have artistic works, designs, symbols, names and images used in commerce, etc. And the ambit of this definition is quite wide, and this definition has been given by World Intellectual Property Organization. And intellectual property, this contains patents, copyright, trademarks, trade secrets, geographical indicators, which actually, enable people not just to, earn recognition, but also get some financial benefit. And very recently, just 2-3 days back, we had World Intellectual Property Day. And this definition, as I said, has been given by WIPO, that is World Intellectual Property Organization. So the question is, why we need intellectual property laws? There are laws, of course, and IPR is also protected by a law. Now the question is, why there should be a law to protect something, or you can say for not rather sharing what we have already invented or what we have already written. Now, just to give you some examples, we write books and we make a lot of efforts in writing books. Imagine, if it is not protected by law, then anybody can make copies of my book or my article and publish in his or her name and start earning money. Similarly, Google came out with a driverless car in the United States, which has been tested already. So if there is no protection, obviously there's a possibility that people may copy their design, etc. And we see a lot of apps which come every day, which we download. So this is important that we have some law which protects our creations. Similarly, if you see movies, you know how big the pirated market of movie is. Sometimes, the actual earning of the movie is far less than the earnings people get from piracy of such movies. So these are some important law, and so that is why we of course need a law which can protect our creations. And these are some of the important intellectual property laws, that is Copyright Act, then we have Patents Act, and we have so many other acts which you can always refer to or read more about it. And as I said, I would be speaking more on copyright because my focus is copyright. So what is copyright? So basically, any creative work can be copyrighted, provided it is unique and did not exist earlier. And as you all know, for any nation or any country, creativity is the basic indicator for progress. And hence, it is important that our creativity is protected in some way or the other. People say that the intellectual property rights are basically, it is a state-created monopoly. But it is true that it is a state-created monopoly. But again, it is for a limited number of years. And why it is there? Because the government wants to incentivize creators. If government does not incentivize creators, or if you do not have such laws, obviously we will not be incentivized to invent or write. So in my opinion, it keeps a balance between the rights of the creators and of course general public good. And as I said in the beginning, that the definition given by WIPO is the ambit is quite wide. So anyone who contributes protectable expression is protected under the law. And this law basically, or rather you can say copyright laws, grants authors or artists or all such creators, protection for their works. And if you want to see more on this particular aspect of copyright, you can go and see section 14 of the Indian Copyright Act. So these are some of the images, for your benefit, I have listed here to make you understand what all can be covered under copyright. So it is software, plays, choreography, paintings, of course, books, and then, designs, photographs, sculptures, etc. So let us briefly see the history of the copyright, where, how did it emerge? So in the 15th century, the idea of copyright emerged. Basically, when the printing press came to the US. And as you all know, every government wants to have control over publications. Though every government says that we want a free press, but actually when you see some of the examples, it's true the world over that the government wants to keep a control on the publication. And that was one reason why, the King of England, he also wanted to keep a control on the publications. And only one company of that government, that is the Royal Company of Stationers, they were actually allowed to purchase copies from creators and publish. And that is how the word copyright emerged. So only one company had the right to publish. But the good thing is that now, during that time, that we have today Delivery of Books Act of 1954, where we are supposed to, the publishers are supposed to put 3 copies in 3 public libraries of all the titles that they publish. So on the same lines, the Royal Company of the Stationers was supposed to give 1 copy to the Oxford University Library, and that was done. There was an agreement between Mr. Thomas Bodley, who was a librarian there in the Oxford University, and this company, that is Royal Company of Stationers. And that is one reason, why still you see that the University of Oxford has libraries named after Mr. Bodley. If you see the history in India, the law of copyright was introduced in India when the British East India Company was established. And then we had another, law of 1914. And today we have Indian Copyright Act 1957. And after 1957, there were about 7 amendments done in the Copyright Act. And these amendments basically are done to ensure that it covers all the newer things. Like, for example, when the law was enacted, obviously electronic documents were not there. But then slowly, it accommodated all the issues related to electronic documents and so many other areas. Like, for example, I think before 99 or so, there was no exception for specially abled people or physically handicapped people. But then after that, these particular provisions were also introduced in the law. Now, the question people have in mind is that, is registering copyright mandatory, or adding the symbol C within circle is sufficient or not? So even if you don't register, that is perfectly fine. But yes, even if you don't give C within circle, you will be protected by copyright law. But, it is always good to have this C within symbol before, the works, say if it's a book, if the copyright is with the author, the C within symbol will be against the name of the author. If it is, with the publishers, then it will be against the name of the publishers. So basically, the C within circle provides a prima facie evidence of the ownership, who owns it. So that is, I think, very important for all of us to understand. Now, if we see the Copyright Act 1957, it stands for legal rights exclusively. This is very, very important. Exclusively given to the authors or creators. There can be, of course, non-exclusive rights also, which we will discuss in the next few slides. So copyright basically, protects works of authorship, whether they are published or not, but they should be in any tangible medium of expression, like, computer software, films, writing, books, etc., etc. And the copyright works in India enjoys same rights and privileges in other countries, which are members of the Berne Convention, which India joined in 1928, and the US joined this in 1988. So what happens, whatever you create here in India, your works will be honored outside India, who are, the countries where, the countries which are member of this Berne Convention. Similarly, the works of other countries are protected here in India. And as I said, whether it is published or unpublished, both are covered under copyright law. And these are some of the important conventions that are listed here. You can go and read more about it. So let us understand about the copyright duration. This question, comes in our life of librarians every day, whether this material can be used or not. So first, let us understand about the copyright duration. So copyright remains in force for a definite period. And as I said in the beginning, that it is for a limited number of years. So for example, in India, the copyright remains in force during or throughout the life of the author or creator, and 60 years after the death of the author. and those 60 years are calendar years. And if there are two authors, then the 60 years will start counting from the death of the second author. Okay. Now, what happens in anonymous or pseudonymous works? So 60 years from the date of publication. So that is the, I mean, where, you know, the author is not known, etc. Then 60 years from the date of publication. And if you want to know more about it, please go and read chapter 5, section 22 to 29. And, you know, I just now said that it has 60 years, it covers 60 years after the death of the author. But if you see historically what happened, there were only 14 years for which the work used to be protected, then it rose to 28, then 42, etc., etc. And now, you know, we have almost 100 years. You know, the copyright duration can last over 100 years because of the fact that, you know, it is throughout the lifetime of the author and 60 years after that. Okay. Now, let me also address the issue of ownership. You know, who owns the copyright? So whether it is the author, the employer, publisher, state, or any other person. But, you know, the librarian has to make a fair judgment of fair use. So what is fair use? Can the librarian give a copy of the whole book to the student or not, or of an article or a chapter? These are the questions, you know, we all have to see every day. So let me tell you, you know, how, you know, ownership goes. So for example, if you have written a document, say for example, if my university asks me to write guidelines about ethical conduct in research and publication. So obviously, you know, my university will have copyright of that particular document. But if I write a book, if I write an article, obviously I will be the holder of the copyright. You know, I will be the owner of the copyright. Similarly, you know, if you know, you are an author, you have published or you have written a book. So if you have not passed on the rights to publisher, then of course you are the owner. But if you have passed on the rights of the ownership to the publisher, then publisher will be the owner. And all government data or publications are owned by state. But of course, you know, people use those data under the mechanism of fair use. So we have to be really very careful about using these documents. So let us now understand what are the rights of creators. Of course, there are some exceptions given in the Copyright Act, but apart from that, you know, the creator can reproduce the copyrighted works. Say, for example, if I have written a book, obviously I can make as many copies as I want. Similarly, I can distribute copies of works. I can distribute it in the class. I can sell it. I can rent it. I can even transfer my ownership, which generally we see that people transfer their ownership to publishers. You know, I, as a creator, will also have the right to produce or prepare derivative works. So what are derivative works? Which are derived from the original work. Say, if I have a book, I can give it to someone to make a movie on that. I can convert an article into book chapter. I can convert my, you know, book into a play. So all these, you know, things are my rights as creator. And of course, you know, the people, dancers or, you know, music artists, they can display or they can play their music in front of an audience. That is the right they have. So, you know, the creators can also grant permission, or which is also called licenses, and those licenses or permissions could be exclusive or non-exclusive. So for example, if we take the example of exclusive right, then I, as an author of a book, ask or give permission only to one bookseller to distribute, or the distributor to distribute my copies, okay? And the non-exclusive example could be, you know, we subscribe to a lot of resources and databases in our library, so we don't become owners, right? We have the right to only use. So that is a non-exclusive rights which are given to a large number of people by publishers. So, there are a lot of confusion about, what is copyright infringement, what is copyright and what is not copyright infringement. I think a lot depends on the court's interpretation. Now, for example, you must be knowing Vasundhara Das, who came to fame with that very interesting song in the movie Lagan. So in a TV show, she sang few lines of one song that was Kajrare Kajrare of Bunty and Bubbly. And the Yash Raj films, they went to the court saying that it is copyright infringement. So the court accepted, technically, it is copyright infringement. But what the court said that, it is trivial violation. It's a minor violation, okay? And the court said, if we consider it as copyright infringement, what will happen then? People, they sing songs in birthday parties, etc., then will be flooded with large number of petitions. So the Yashraj films lost the case in the court. So a lot of things depend on the court's view. Now, coming to the digital or electronic documents, or we can say online classes, the copyright issues become highly complex. Unlike physical classrooms, say, for example. Under physical classroom, you have a lot of exceptions, but in electronic documents, there are a lot of restrictions. There are huge restrictions in electronic environment. So we will discuss few things. And before that, let me tell you what digital rights management is, which is basically, which comes into play in all electronic documents or electronic information. So you must be subscribing to Tata Sky or any other such product. So obviously only you can watch it, okay? Or whom you give, like Netflix, etc., whom you give the credentials or access rights. Now, DRM or digital rights management is all about access. Like, for example, who are authorized users? What can the users do with the content? Can they read? Can they download? Can they print, etc., etc.? When can the users access? There can be embargo on some of the products. Obviously you cannot use it immediately. Where you can use that, there could be geographical restrictions, how long you can use it, because you all know, we subscribe to a lot of things. So it's generally for 1 year or 3 years. So, this is DRM. So what is no DRM? No DRM is, when such restrictions are not there, people can use things freely. Now, the question, which we all have to answer is, how do I decide about using any copyrighted material? But before we get into this questions, or we try to find answers to these questions, let me just tell you a few things about these 5 things as to what is public domain, what is exception, what is licensing, what are permissions, what is fair use. So I think once, we have basic understanding of these 5 things, probably we will be in a better position to understand it. So what is public domain? Public domain refers to creative works that are not protected under copyright and any other form of IPR laws, okay? The public owns such works and not an individual, okay? No permission is required to use such works, right? Now, a lot of people say that, I'm sure not librarians, but a lot of people say that, everything which is there on the internet is public domain information, which is of course not true. Similarly, all open access content cannot be said to be in public domain. That might also be having some copyright issues or copyright associated with those material. So the work falls under the public domain if the copyright term has expired. We just discussed, lifetime of the author plus 60 years. The copyright owners put his or her own work in the public domain, which is called dedicated works, and the works which cannot be copyrighted. For example, titles of books, you must be seeing that a lot of books have same title, but obviously the authors are different. Facts, ideas, slogans, or short phrases, these are not copyrightable, okay? So if you go to the Google Images, so there, we tend to use images in our, PPTs or classrooms, etc., without realizing that they must be having some kind of copyrighted associated with it. So the best thing would be to go to tools and probably see the Creative Commons licenses images, because these are liberal licenses associated with it. If we get time, probably we'll discuss that also. And similarly, on Flickr, you see these are all Creative Commons images. So if you go to, if you want to use a clip of a video in your own video, then possibly again you can filter it with Creative Commons licenses videos and use that. And this is the Creative Commons licenses website, which you must go and understand what these things signify. What is the meaning of CC BY? What is the meaning of CC BY SA, BY NC, etc., etc.? So that I think I suggest that all the young librarians who are attending this program possibly can go to creativecommons.org and see what these things are. Now, the next thing, which we want to discuss is exceptions. Okay, what are the exceptions given in the Copyright Act? So one exception is for classroom. Okay. And this is for, face-to-face classroom, or you can say physical classroom. And in a physical classroom, a teacher has a lot of freedom to use a copyrighted material in his or her classroom. They can distribute copies of any copyrighted material, like, for example, articles, etc., provided, that institution or organization is not for profit organization. Okay. And the work should have been lawfully made, or there should not have been any reason to believe that the work has not been lawfully obtained. Okay, so also, it is the responsibility of the teacher to sensitize students that these are copyrighted material and they should not distribute it. Now, before the start of the program, I was discussing with Dr. Sri Kumar that a lot of people, they distribute a lot of material. What do you mean by distribution? Distribution means, for example, if you put it in a large group, if you put the copyrighted material on the internet, so that is distribution. Even, sometimes if you put something on intranet, that is your own institution's internet, there could be an issue of copyright infringement, depending on the kind of content which you have put on the internet. And even if, somebody is recording the proceedings of the classroom, then it is very important for all of us to understand that we cannot distribute. So when we come to online classes, the teacher or the institution has to ensure that there is a closed registered group of students who can use or who can, view that electronic classroom. Institutions themselves should create certain mechanism, which ensures that the copyright is protected of, creators. And how can you do this? Obviously, there are a lot of restrictions given on our IP address, etc., etc. The amount of material used in a physical classroom has all exceptions, which may not be true in an online class. And I said it earlier also. Obviously, credit has to be given, and the students must be sensitized that the information is copyrighted. And to the extent possible, not to the extent possible, but you should definitely not interfere in the technology which has been there for protecting such copyrighted material. You can, as a teacher or instructor, can consider locking of files, disabling right-click, streaming, use of low-resolution pictures, and not providing, download option on your videos. And when you use the subscribed e-resources of your institution in your online classroom, you have to be very sure that you do it as per the provisions of the license. If you are not sure what are the provisions, maybe you can meet the librarian, you can speak to him, or you can read the agreement. Now we come to the second exception, which is available to the library, but again, it is for public libraries. So public libraries does not mean, the public libraries that we understand in the context of libraries, but it is those libraries which are not for profit libraries, okay? So what we can do in our, libraries, we can make 3 copies of any damaged or about to be damaged material, provided, this is very important. We just cannot go and make 3 copies, but provided, that damaged material or about to be damaged material is not available in the market at a fair price. And the fair price is very subjective. The understanding of fair price is very subjective, because for Geo Institute, the fair price of a book which is costing 100 rupees, maybe 500 rupees but for my university, the fair price could be just 200 rupees. So I think it is a very subjective issue, and we have to make proper judgment about this. The 2012 amendment also provides us the flexibility of, you can say, storing or digitizing the print material that we have in the library. But again, we have to be very, very sure that, of course, whether you really need it or not, that all depends on you. And also, this is for preservation. That is for the purpose of storing only. You cannot, again, distribute. But having said that, let me say that, of course, it cannot be used in such a narrow sense, that preservation. So within the libraries, you can make such material, such copyrighted material, which is in electronic format, which you have, of course, digitized from the existing books that you have. You can make them available in the premises of your library, but not on internet, because of the fact that it is the law says it is only for storing and preservation. And if you have photocopy machines, then those photocopies should not be for commercial purposes. It should only be cost to cost. And if possible, libraries should always notify the copyright compliance in the library wherever is possible. And there are a lot of exceptions, for especially able persons, like, you can convert all text into voice for especially able people who have sight deficiency and give it to them. Nobody will stop you, because this is one of the exceptions and one of the best, I would say, the exception given in the Copyright Act. After exceptions, let me also discuss about licensing. So we all as librarians sign licensing agreements with publishers, okay? And those license agreements are basically permissions to use copyrighted material. And as I said earlier also, that digital content is more restrictive than the print material. So, like, for example, you can sell a second-hand copy of your book in the market, but you cannot do it with electronic book. Okay, then, the issue of, what is available on IP, what is available on user ID and password basis access. Whether, the licensing agreement allows us to, remotely access our resources, what are the downloading restrictions, whether the licensing agreement allows us to send material to other libraries on interlibrary loan. I was also discussing this issue with Dr. Sri Kumar earlier in the day, that people do not understand that we are not allowed to send or give a lot of things on interlibrary loans so freely, but people do it quite freely, what I see on various WhatsApp groups and of course on emails. Now, whether the product is DRM or not DRM, that also we have to understand. Is there any platform fee or not? Because sometimes, you feel that the product is quite, available at a very reasonable price. You buy it, but then you realized after 3 years that it had a clause which said that you will have to pay annual platform fee or access fee after 3 years. Then what is the perpetuity clause? Is the does the perpetuity means only 15 years, or it is for unlimited number of years? For my understanding, it is for unlimited number of years. You get access to a particular product, but some of the publishers, they say that for them, it is 15 years. So what are the preservation right or archival rights that we have? Can we really make course packs from the electronic copies of articles that we have access to or we have subscribe to. Now, what happens if a journal is discontinued? Is it available on clocks after it is discontinued or not? So, distribution of e-content generally carries severe restrictions, and I've said it again. And unlike print material, online content comes with huge restrictions. So this was about licensing. Now, let us discuss the second last thing, that is permissions. And after this, we'll discuss the last thing, that is fair use. So what is permissions? Obviously, you sometimes need to get permissions to use a copyrighted material. And for this, you have to identify who owns the copyright. Okay, it is your job to know who owns the copyright, because you want to use copyrighted material, not the person who has copyright ownership with him or her. So we can, simply send a formal request. It may be in the form of email, etc. We must have clarity on the scope of permission required. Whether we want to use a particular, say, photo in an article or in a book. If we are using it on a book, whether it is on the cover page or it is somewhere in the book, because there's a possibility that if you are using it inside the book, the copyright owner may not ask for any fee. But if you say that you want to use it on the cover of your book, then possibly that person can ask for some fee or royalty, whatever you can say. And sometimes, copyright holder is not identifiable or traceable, but obviously you need it. So you will have to anyway ensure that you get the permission. So the last thing is, fair use. So what is fair use? So fair use is something, or is a legal doctrine where, you're allowed to use a small portion of a copyrighted material without any permission. Okay, so that is called fair use. There are a lot of things, like a lot of people take membership of Indian Reprographic Rights Organization, but I really don't understand why we take the membership of this, because, you can apply the law and you can use what you want as per the norms. And even if you take Indian Reprographic Rights Organization membership, again, you'll have to follow the same law. And, I said to you initially that all copyrights are protected by different countries, and almost it is standardized internationally. Okay, but when it comes to fair use, it is little complex. Now, so far we discussed what public domain is, what exceptions are, what licensing is, what are permissions, and what is fair use. And now perhaps we all are in a better position to answer this particular question. How do I decide about using any copyrighted material? And the answer of this should be with every librarian or even a faculty member, but more with librarians, because we are information experts, we are knowledge managers. Now, these are 6 things I have listed it out here. One is, we'll have to check whether the work is copyrighted or not. So if it is copyrighted, if it is not copyrighted, of course, there's no problem. But if it is copyrighted material, then I will have to see if there are any exceptions in the Copyright Act. And say, for example, there are no exceptions, then I will go and, explore the third point. That is the work protected by any license? So if the license allows me to use that work, I can do it. I can use it in my work. But if not, then I will explore the possibility of using the copyrighted material under the fair use mechanism, right? Then say, if I find that I cannot use it under this mechanism, then I will explore the possibility of getting permissions from the copyright holder. Say if I don't get the permission, then or if I don't get to know who holds the permission, then I will again explore the possibility of using the copyrighted material in my work under the fair use mechanism. So these 6 things, in my opinion, are very, very important for all of us to understand. Now, I came across a fair use, checklist on the Columbia University website. I say how you decide whether it is a fair use or not. So they have given a very interesting checklist of, of how we can decide about using a material. And these are the 4 checklists. One is purpose of use, then nature, then amount of use, and effect of use. Now, if we see the purpose of use, if it is, for example, for the purpose of teaching, research, scholarship, non-profit education, if it is, of course, a non-profit education institution, for comment, criticism, news reporting, etc., this is perfectly fine. If it is transformative work or productive use, it is perfectly fine. One example of transformative productive use is Hathi Trust, okay, that website. The other, for better understanding of all of us is that a Clear Tip or Make My Trip, where, there are different websites and they actually, give you the fare of all the flights at one particular platform. So that is called transformative work. And as long as, the usage is restricted or access is restricted, then there's fair use. For parody also, it is fair use. But if it is for the commercial purpose, if you want to make profit out of it, if it is for the purpose of entertainment, then it is not. It goes against or it opposes the fair use mechanism. Now, just to give you an example of entertainment and research and teaching. Now, if a teacher shows a movie in a classroom, of course, which is copyrighted, then it is fair use. But if the students go and show this movie in their club, then it will go against the fair use mechanism. So that is something we have to understand. Now the next is nature of material being used. If it is published work, it is easier to use it under fair use mechanism. But is it unpublished, then it does not really does not favor fair use. It rather opposes fair use. Similarly, if the copyrighted work which you want to use has some factual information, or if it is not a very highly creative work, then it's perfectly fine. But if it is highly creative work like films, plays, etc., then it opposes the fair use mechanism. The third is amount of use. If it is a small amount, there's no problem. But if the large portion you want to use, then there is a problem. And the last is the impact of use. If the impact of using that copyrighted material by you is actually going against the interest of the copyright owner, then it actually opposes fair use. So I think these are few things which I thought would be important for you to understand. And in this also, if say for example, I can make probably one copy, okay, of a particular article, but can I make more copy? I cannot, And if I say, for example, by making that copy, is it affecting or it is impacting, or if the effect of that usage is in commercial context of the person who has the copyright, then it is not allowed, or you can say it opposes fair use mechanism. Now, the interesting thing, here in this, I said amount of use. If it is a small amount, then there is no problem. So, Dr. Srikumar, I will take, I think already I have completed. I'll take 5 minutes more and then.
You can take enough time because we have 45 minutes we have set aside for reflection. So
okay, that is why I wanted to restrict myself on for 45 minutes only. But thank you for giving me some more time.
Yeah, you have enough time. You can even stop at 6 o'clock, and then we have 30 minutes for interaction. No problem.
Oh, that's great. That's great. So yes. So what I was saying that here the fair use mechanism says that if it is a small quantity, then there is no problem. But if you are copying large portion, then it opposes fair use, right? But this case, this is a very interesting case, which you, I'm sure, must be knowing. That was a case, with Rameshwari Photocopy Services, which was working from University of Delhi. So what happened that some publishers, went against this this Rameshwari photocopy to the court, saying that this photocopy service in the University of Delhi is making multiple copies of their books. And then they also went to the Supreme Court because the High Court rejected that, or you can say the High Court went against what they wanted. And the decision was in favor of Rameshwari photocopy, which allowed Justice Enlow allowed this Rameshwari photocopy to make copies of the books, saying that India is a country where the students are not able to even pay their fee, etc. People cannot afford books, the cost of books here in our country, and so many things or justification were given by Justice Enlow. And as of now, but what I was saying, that they went to Supreme Court, but then they withdrew their case from Supreme Court, saying that they do not want to get into any kind of fight with their stakeholders. So the case was withdrawn by them from the Supreme Court. But what I'm trying to say is that here so far this judgment prevails, because nobody went against this decision, any of the other high courts of any of the other states. So this judgment, prevails as of now. And this particular, I really enjoyed reading this particular editorial, which was published in 2016 in the Indian Express, which says that ruling in the University of Delhi copyright case reflects the inability of Indian courts to integrate legal outcomes with robust business models. And I would suggest that you please go and read this interesting editorial. And also, you should read the judgment, and you will find it quite interesting. Now, I was, telling you about this transformative use of copyrighted material. So Hathi Trust, you all are librarians, you know what Hathi Trust is. So Hathi Trust is basically a place which actually hosts a large number of books from different libraries of the United States, and I'm sure there's some other libraries also. And there are all this material is free from copyright. I mean, those who have where the copyright has already expired. And apart from this, you will find the bibliographic information of a lot of other books. So what happened, in 2008, that again, publishers went against this particular agency or society, and they said, that it is copyright infringement. But the good thing was that the decision was in favor of Hathi Trust, and which allowed them to keep hosting all the material that they had. But unfortunately, when it comes to the Internet Archive, during COVID, they made the library open to everybody, which was called, I think, National Emergency Library. Yes. So HarperCollins, HarperCollins and Wiley also, they went against this particular agency, and they said, it is mass copyright infringement. And finally, and unfortunately, they had to withdraw, they had to, remove this open library permanently from their website. This is something, which everybody, all researchers know, that is Sci-Hub. So it was accessible to everybody, but now it is not accessible to us. And the reason is, of course, legal battle going on between Sci-Hub and the publisher. So I'm not sure when, this particular site will be available. And it is a loss for, lakhs of researchers in our country, because of the fact that, we are if not poor, then, we are not a rich country. And people here struggle for accessing material. Now, I will give you an example of, let me give you an example of Jio itself. Now, Jio has must be having a lot of money. I'm sure Dr. Sri Kumar has a lot of money at his disposal for subscribing to electronic resources, and their faculty, or even the faculty of IIMs, etc., they will have access to the finest resources of the world. Because the budget, if you see IIMs, the library budget for electronic resources, sometimes it it ranges from 7 to 20 crores rupees. And if you see a university, there, the budget may be a few crores, maybe 2 crores or 1.5 crores. There are colleges where, budget is not even 10 lakhs. There are libraries which do not have any budget. Okay, there are management institutions, to my surprise, in Ghaziabad and other such places where, they don't subscribe to a single resource and they run MBA courses. So first thing is, I don't understand how they really, their students cope up with, or are able to compete with other students. Why libraries cannot have access to these resources. Obviously, they don't have money, so they don't subscribe to it. So basically, there is a digital divide, huge digital divide between, you can say, the premier institutions of this country, or you can say private and premier institutions, both. And at the same time, the government-run institutions or public institutions which do not have money to subscribe to the resources. So obviously, then, people expect that the university faculty should compete with IIM faculty. I mean, I leave it on to you to think, can they do it or they can't? So this is an important thing, this, you can see this news laundry, what happened. India today went against news laundry, saying that they are doing copyright infringement. They are showing India Today clips on their website, on their, in their programs. But what I said in the, when I was discussing, let me just go back to this particular slide. So what I was saying that, so the purpose, if the purpose is comment, criticism, news reporting, then it favors fair use. And that is perhaps the reason why, the court decided in favor of news laundry. And this is an interesting thing, which I thought I must tell you. So while concluding, let me tell you that as a librarian, we all must understand the fair use, because if we understand, probably we can make this thing, we can propagate these things, we can tell our faculty, because faculty, when they come to the librarian, they have a lot of expectations from them. They expect that librarians are able to tell them what is copyright infringement and what is not. So that is the reason why we have to understand this fair use mechanism. We must, as librarians, read fine prints of licensing agreement, because say, just to give you an example, the agreement may say that authorized users are the students and faculty. But I, as a librarian, may want that the visitors of the university, who come for attending the conferences, etc., they should also be part of authorized users. Also, we have to keep our permissions safe. The reason is copyright duration sometimes, as I said, can be 100 years. We all have to, respect intellectual property rights of others as academicians. Not just because of the Delhi High Court decisions, we go and start making photocopies of all the books. Let me tell you that there was, when I was working at IIM Indore, then there was a library, and the library in charge, of course, he was not library professional, one professor, he said, they will start making copies of all the books and distribute to the students. So that is probably not fair. This is against the spirit of the Copyright Act. And to the extent possible, we should publish in open access and promote Creative Commons cause. So with this, I would like to thank you for being so patient, and let me just thank Dr. Sri Kumar once again, and of course all of you or Geo Institute for giving me this opportunity to interact with you. Thank you, Dr. Sri Kumar. Thank you, participants.